Speaker. It's Mr. Mati, Public Prosecutors, Mr. Mkunu, Interpreter, and Interpreter accuses English speaking, and for the defense we have Mr. Ibrahim matters in the court today for judgment.
So what happens with the matter when we're done with the judgment?
Was on the matter for fair investigations. We give it a date in Protea Court number 10 for investigations to be done and concluded in that court. The date I will suggest in Protea will be the 24th of June. If the date is suitable, my then according.
Okay.
Your Worship, the 24th of June is acceptable.
Fine, the applicant must sit down, solo. The accused in this matter is named as Fazila Khan-Seedat Khan on the face of the record, that is the J15. It reflects her date of arrest as the 6th April 2020 and her age as 62 years. Her residential address is stated as 8274 Scorpio Drive, Venetia, Extension 9. The existence of the address has been verified by the police as she was arrested there and eventually made her first court appearance before this magistrate on the 8th April 2020 in respect of this case. At that stage, there were no drafted charges, but Prosecutor Maunye considered in addressing to court that of the dockets before him, the total amount of the offenses did not qualify them as so-called Schedule 5 offenses. There are now 2 drafted charges of fraud in the case. The victim of the first offense is one Adam Seedat, while that of the second is Ahmed Patel. They were allegedly defrauded of 105,993 rand and 49,497 rand respectively in what the prosecution perceives as scams. Both amounts appear to be loss actually incurred by the victims as per the investigating officer's first affidavit, Exhibit C. Now there's preliminary issues that this court would want to deal with before going to the merits of the bail application judgment. The first is Section 6011A of the Criminal Procedure Act 51 of 77, confirmation and the onus for Schedule 5 offenses. That provision is to the effect that irrespective of the offense currently charged and at any stage before pleading is a written confirmation by the TPP that is Director of Public Prosecutions, that an accused to be charged with an offense referred to in Schedule 5 or 6 of the Criminal Procedure Act may be handed in at court by the prosecutor as soon as possible after issuing thereof and form part of the record of the court. Upon mere production thereof at a bail application or bail proceedings, such written confirmation furnishes prima facie proof of the charge to be brought against an accused person. So if a written confirmation under Section 611A of the Criminal Procedure Act is produced and not successfully or gainsaid, not only does it cast an evidentiary burden on the accused to prove entitlement to bail, but also shift the duty to begin and lead such evidence as would prove that entitlement before court. A document by one Belivia Vuma bearing a date of the 9th April 2020 with an imprint of the date stamp of the same date from the Indonesia office of the NPA had been attached to the court record by the time the actual bail application started before me. Said documents purports to be written authority to proceed with bail application in the regional court in terms of Section 65, Section 650, subsection 6C of the Criminal Procedure Act. It reads that Vuma duly authorized thereto by the DPP for the South Gauteng Division of the High Court deemed it expedient and unnecessary for the administration of justice that the bail application in this case, in which the accused is charged with the offense of theft referred to in Schedule 5, must be conducted in this regional court. The matter of the schedule under which the offense results in the Criminal Procedure Act was argued before me by Mr. Maunye for the state and Mr. Karolia for the accused during first appearance on the 8th April. Mr. Maunye correctly pointed out that the state needed no written confirmation or certificate from the DPP at that stage before bringing proceedings for what he saw as a Schedule 5 offense before the regional court. He was correct in that Section 50, subsection 6C has no bearing to bringing a Schedule 5 offense bail application or bail proceedings before a regional court. Therefore, the written authority to proceed with bail application in the regional court in terms of Section 56C by Vuma is clearly wrong as far as it purports to do so for this case. That is so because Section 50, subsection 6C of the Criminal Procedure Act says the bail application of a person who is charged with an offense referred to in Schedule 6 must be considered by a magistrate's court as opposed to a regional court, provided that the DPP concerned or a prosecutor authorized thereto in writing by him or her may, if he or she deems it expedient or necessary for the administration of justice in a particular case, direct in writing that the application must be considered by a regional court. It is for that reason, as I saw it, that the renewal form by Vuma used mentions Schedule 6, but she changed the schedule in longhand in circumstances as I see it, wherein she was not supposed to Schedule 5 in order to bring this bail application before the court. So the gist of this is that that document by Vuma is not necessary for a Schedule 5 bail application to proceed before the regional court. And I was worried that Mr. Bamji appeared to consider that document to be a Section 60, subsection 11A confirmation that the accused would be charged before this court with a Schedule 5 offense. That's so because Mr. Bamji was not there when the argument as to scheduled by Messrs. Maunye and Karolia took place before this court, I ruled at that stage that it appeared to be a Schedule 1 offense and that a bail application could proceed the next day before my colleague. At that stage, the offenses had not yet been drafted and the document by Vuma was not there. Now, Schedule 5 of the Criminal Procedure Act says, in respect of a person that's not a law enforcement officer, the amounts involved to qualify a fraud or theft to fall under it should be more than 500,000 rand. For an offense against a non-law enforcement officer to qualify to fall under Schedule 5 of the Criminal Procedure Act, in a case such as this, the amounts involved in the fraud or theft should be more than 100,000 rand, and it should also be alleged that the offense was committed by a person or group of persons or syndicate or an enterprise acting in the execution or furtherance of a common purpose or conspiracy. So these allegations were there with the drafted charges as well as the document by Vuma when Mr. Bamji considered that indeed the offense falls under Schedule 5 of the Criminal Procedure Act and accepted the duty to begin and lead evidence in this bail application. Therefore, his concession appears to have been well made. And I will then proceed with this bail application on the basis that indeed it is a Schedule 5 offense in respect of which the accused has been arrested, despite the earlier ruling that I had made on first appearance that the offense seemed to be one under Schedule 1 of the Criminal Procedure Act. Now, that is important as I see it, because I had made a ruling. And if Mr. Bamji mistakenly made a concession that is it's a Schedule 5 offense, whereas it's not, it then, as I see it, means that the accused could be prejudiced. Because in the recent case of Road versus the state, Nicholas, Judge of Appeal, had this to say at page 5 of paragraph 7, and I quote, "Similarly, the Constitutional Court, in upholding the constitutionality of Section 6 of the Criminal Procedure Act, found that the seriousness with which the legislature viewed bail was underscored by the fact that there were major amendments in 1995, 1997. For the first time in South Africa, the bail legislation focused not on the accused but the community. Clearly, said the Constitutional Court, the legislative intention was to curtail bail for suspects charged with very serious offenses and to this end, Section 11 was introduced in 1995 and was replaced by even more stringent provisions for persons facing serious charges listed in Schedule 5 and extremely serious charges listed in Schedule 6. The natural and direct result of Nicole J.A.'s above reasoning is that in bail applications, this court has to focus more on the community's interests than those of the accused, which have been curtailed. That wrote judgment. The neutral citation of it is bracket, open and close brackets, 1007/2019. Again, open and close brackets, 2019, ZASCA 193. The other preliminary issue is to give full reasons for the postponement given to the state after the closure of the accused case in this bail application. At the court's direction, the investigating officer testified and got cross-examined on the reasons he gave under oath for seeking the remand. Before leading the investigating officer, the public prosecutor asked the court for directions as to whether to lead him on those reasons only or on both those and the merits of his opposition to bail. After the concession that the offense results under Schedule 5, Mr. Bamji was eager to read the accused bail affidavit while the state wanted a postponement so that the investigating officer verifies the accused passport and get further information on additional dockets that were opened against her. I'd already ruled during the first appearance that a similar 7-day remand that was sought by Mr. Maunye not be given for the asking, as Section 60, subsection 5D of the Criminal Procedure Act gave the court a discretion. Having ruled that the offense charged at that stage fell under Schedule 1 of the Criminal Procedure Act, I stated that bail is ordinarily dealt with speedily, especially for scheduled offenses. But as it was already late, I rolled the matter over to the following day for the investigating officer who was not present to come and start opposing bail. At that stage, I felt that since the accused had been in custody since 6 April 2020, the issues the state wanted a remand for should already have been dealt with by the 8th of April to facilitate the speedy consideration of bail for a Schedule 1 offense. I still had the same view as to the agents of bail hearings when Mr. Banja's concession changed the offense to Schedule 5. However, that change resulted in the bail application starting on the premise that the continued detention of the accused was the norm. In Sachin versus Supersad versus the state, Hendricks J. said the following at page 8, paragraph 21, and I quote, "In respect of Schedule 5 offenses, the onus is on the appellant to satisfy the court that the interests of justice permit his release on bail. In respect of the test for interests of justice, the bail application must start on the premise that the continued detention of the appellant is the norm. This applies equally to both Schedule 5 and 6 offenses in my view." Close quote. The written judgment by Hendricks J. was delivered on the 18th January 2019 at the KwaZulu-Natal Durban Local Division of the High Court of South Africa. Again, in State versus Yanta, 2000 Volume 1 SACR 237 brackets Transkei, the court held that the view at page 249C to D that on a proper construction of Section 11 of the Criminal Procedure Act, the interests of society and the proper and effective administration of the criminal justice system are supreme to and the personal interests of an accused are secondary. However, in order to strike a balance between continued detention and speedy consideration of bail, I allowed Mr. Bamje to read the accused bail affidavit, directed that the investigating officer testify and be cross-examined on the weight and compelling need to postpone now that the offense had become a Schedule 5, and then granted the remand. I was convinced that the investigating officers need to verify whether the passport of the accused were lawfully issued and that the different names in them were indeed hers was relevant to considering if she could evade trial, as well as the means and travel documents with which she could easily do so without being caught out. That is relevant to section 64B read with section 60 subsection 6C of the Criminal Procedure Act. In State versus Stanfield, 1997, volume 1, SACR 221, bracket C, it was held that denial of bail would be in the interest of justice only if one of the factors set out in section 60 subsection 4 was probable. So to the extent that the postponement was asked in that regard, I granted it. But the second reason was that the investigating officer also testified that he required information from other dockets that had been opened against the accused here in Gauteng, the Western Cape, and KwaZulu-Natal. Although he considered that the accused had not yet been charged in respect of those dockets, the accused was subsequently charged for one case that she made an application for it to be joined in this bail hearing. Hendricks J. in Supersad's case said the following at page 13, paragraphs 40 to 41. The number of pending charges faced by the appellant at the time of the bail application and the uncontradicted evidence presented that there are likely to be further charges laid would, in my view, certainly weigh heavily in the consideration as to whether or not the appellant would likely evade his trial. The evidence of the investigating officer that the number of pending cases affects the resolve of the appellant to evade trial cannot be faulted. Such was not controverted or challenged in any way, and the court was on the facts of the current matter entitled to rely on same. In addition, the merits of a further submission made by Mr. McDonald cannot be underestimated, namely that given the number of counts faced by the appellant, the pending sentencing case, the possibility of 3 further charges being laid, and the value of the alleged fraud in the 2 Durban matters being approximately 8 million rand, if the appellant was released on bail, this would undermine or jeopardize the objective and or proper functioning of the criminal justice system. In State versus Patel, the court referred to an English decision, R versus Phillips, in which it was held that it was undesirable to grant bail where there was a likelihood of a repetition of the offense by the person asking for bail. So for those reasons, if one would recall, I had stated that there's a Durban case that has reference to these matters that I still wanted to look at. It was Supersad's case. Hence, I did not immediately give the reasons, but it was the same reasons that prompted me on the second ground to grant the postponement that the state required in order to get information. To continue then with the judgment, I must hasten to point out that although the above reasoning in Supersad justified the postponement I granted to the state, that case, though similar to this, differs from it in these important respects when it comes to considering all the merits of this bail application. A, the amounts involved in the cases in respect of which bail was or is sought. That is 350,000 Rand in Supersad and 155,490 Rand for this case. B, the number of charges of fraud involved. That is one count faced by Supersat and two faced by the accused in this case. In other words, Supersat faced one count for a large amount allegedly defrauded by him in his formal bail application, whereas our applicant's case concerned two counts for a smaller total. C, as opposed to Supersat, the accused has a verified fixed residential address where she got arrested, whereas there was no certainty as to where Supersat resided. D, there was a warrant of arrest against Supersat arising from failure to appear for a case pending in court, thereby breaching bail conditions. E, Supersat faced 7 counts of fraud across the country, and there were cases pending in court. On the other hand, the accused in this case has 2 cases pending in court, that is this case and the one I transferred the original court after refusing to join it in this bail hearing. F, in respect of just 2 Durban matters, the amount involved for Supersat was 8 million rand, whereas in this bail application, despite already being charged in Gauteng and having other dockets opened across the country, no amount of money approximating 8 million rand has been mentioned as having been defrauded currently in this case. H, the charge sheet in this matter alleges that the accused and her companions executed a common purpose in doing the offenses, whereas it's not clear from Supersat's case that others were involved with him in committing the crimes. In other words, despite the allegations that the accused acted with others, it's fact that her son and husband are on bail, though fingered in her matters. I, Supersat's fraud matter spanned a crime spree from the period of time 2016 to 2018. That is 2 years of committing crimes. But the cast numbers, that is, of the dockets against our applicants mentioned in the 3 affidavits of the investigating officer in opposing bail are Randfontein cast 527 of 9 of September 2019, Bramley cast 31 of December 2019, Athlone cast 109 of December 2019, Joburg Central cast 847 of October 2019, Athlone cast 269 of March 2020, Grassy Park cast 547 March 2020, Umzinto cast 41 of April 2020, Lenasia cast 38 of April 2020, Lenasia cast 51 of November 2019, that's this case, and Lenasia cast 177 of April 2020, and Lenasia cast 176 of April 2020. The first affidavit, Exhibit C of the investigating officer, alleges an advert which was part of the scam was flighted in May 2019. It will thus appear it's over a far shorter period of time than that in Supersat's case, that the offenses were allegedly committed by the accused. But I do recall as well that the investigating officer's affidavit says the previous month in April, the accused had quoted the patterns. So it would appear that the period is 13 months, still far shorter for committing crimes than for Supersat. But more cases than Supersad faced have emerged that involved the bail applicant in this matter. So Supersad's case can be seen as a case in point here to the extent that it provides a clear example of some of the problems or factors to be considered in this bail application. That's why that judgment was scrutinized against the circumstances of this case. However, in State versus H 1999, Volume 1, SSCR 72, brackets W, Labe held that in considering exceptional circumstances, what a court is called upon to do is examine all the relevant considerations as a whole in deciding whether an accused person has established something out of the ordinary or unusual, which entitles him to relief under Section 60, subsection 11A. This court is therefore bound to examine all the other matters relating to where the interests of justice lie in terms of Section 60, subsection 11B in this bail application. One such consideration is the strength of the state's case. In State versus Koch, 2003, Volume 2, SSCR, page 5, brackets SCA, here acting judge of appeal stated that in the context of Section 60, subsection 11A of the Criminal Procedure Act, the strength of the state's case has been held to be relevant to the existence of exceptional circumstances. There's no doubt that that strength or weakness must be given similar consideration in determining where the interests of justice lie for the purposes of Section 60, subsection 11B. When the state has either failed to make a case or has relied on one that is so lacking in detail or persuasion that a court hearing a bail application cannot express even a prima facie view as to its strength or weakness, the accused must receive the benefit of the doubt. So the corollary of the above statement from Cox's case is also true in my view. That is, where the state's case is strong and or persuasive, that is a situation that may have adverse consequences for an accused who is a bail applicant. That strength or weakness of the state's case has to be considered in relation to whatever response, if any, made to the charges by the bail applicant, preferably through tested oral evidence. In State versus Branches, 2003, Volume 2, SACR 575, brackets SCA, at 577, Shongwe, acting judge of appeal, stated at paragraph F of page 7, and I quote, "The appellant failed to testify on his own behalf, and no attempt was made by his counsel to have him testify at the bail application. There was thus no means by which the court could assess the bona fides or reliability of the appellant, save by the say-so of his counsel." Again, in State versus Matebula, 2010, Volume 1, SSCR 55, brackets SCA, the tone of her judge of appeals judgment at paragraph 11 to 12 disapproved of the way the accused defense to the charges was presented in this bail application. Paragraph 11 reads, "In the present instance, the appellant's tilt at the state case was blunted in several respects. First, he founded the attempt upon affidavit evidence not open to cross-examination and therefore less persuasive. Compare State versus Binar, 1992, Volume 1, SSCR 178, brackets W at 180H. Second, both the denial of complicity and the alibi defense rested solely on his say-so, with neither witness nor objective probabilities to strengthen them. The vulnerability of unsupported alibi defenses is notorious, depending as it does so much upon the court's assessment of the truth of the accused testimony. Insofar as the appellant suggested that the police had extracted an inadmissible confession from him or his co-accused, he provided no detail which might have enhanced either his or their reliability or credibility. And then paragraph 12 reads, but a state case supposed in advance to be frail may nevertheless sustain proof beyond a reasonable doubt when put to the test. In order successfully to challenge the merits of such a case in bail proceedings, an applicant needs to go further. He must prove on a balance of probability that he will be acquitted of the charge. And then the judgment refers to S versus Botha, 2001, volume 1, ACCR 222, brackets SCA, at 230H, S versus Failune, 2002, volume 2, SACR 550, brackets SCA at 556C. And then it continues. That is no mean task. The more especially as an innocent person cannot be expected to have insight into matters in which he was involved only in the periphery or perhaps not at all. But the state is not obliged to show its hand in advance, at least not before the time when the contents of the docket must be made available to the defense, as to which C. Shabalala and others versus Attorney General of Transvaal and another 1996, 1 SA 725, bracket CC. Nor is an attack on the prosecution case at all necessary to discharge the honors. The applicant who chooses that route must make his own way and not expect to have it cleared before him. Thus, it has been held that until an applicant has set up a prima facie case of the prosecution failing, there is no call on the state to rebut his evidence to that effect. Compare State versus Failune at 561F to G. And there ends paragraph. It will thus be clear from the above decisions that to the extent that our bail applicant had a go at the case alleged by the state on the drafted charges, oral testimony tested by cross-examination is more preferable than her mere words in an affidavit, as well as the say-so of her attorney, that she would probably be acquitted on the charges. In Dika Mosikili versus the state, it's case number A330 of 20 of the Free State Division of the High Court of South Africa in Bloemfontein, a judgment delivered on 25th May 2017. Rampai J stated at paragraph 6, at page 16, paragraph 46, the following. As it is in a bail application governed by Schedule 6, our law places the onus on the detained person seeking to be released on bail to show that on the evidence he is likely to be acquitted at the end of the pending criminal trial. Now, although this is a Schedule 5 bail application, what was said by Rampai J is opposite here. And then he continued at paragraph 47 of that judgment. It must be borne in mind that the appellant did not adduce oral evidence to discharge the onus of proving that exceptional circumstances existed which warranted his release on bail. Instead, he relied on his affidavit, not that it was wrong to do, but such affidavit was devoid of any substance. Most of his affidavit generates much heat, but little light on the cardinal question. On what substantive grounds can it be found that he is likely to be acquitted? Now, our bail applicant's affidavit suffers from the same shortcomings that Rampai J pointed out in Dika Mosikili's affidavit. She stands accused of defrauding the globular amount of 155,490 rand from Seedat and Patel in what the state alleges to be scams. Now, the 7th edition of the Oxford Advanced Learners Dictionary, that is the International Students Edition, says a scam is a clever and dishonest plan for making money. This is not a trial, but serious myopia or evasiveness would result in one disputing the offenses charged, not addressing whether the accused has or had a business, and what proof besides empty word there is of its existence. Her response to the charges was rather lukewarm, if one were to have regard to paragraphs 6 to 8 of her affidavit. It amounted to the following. 1, she owned and operated New Heights Travel, an agency dealing with Hajj and Umrah religious visits to Saudi Arabia. 2, people booked and paid for said travels for September 2019. 3, travel rules to the Saudi Kingdom changed, and she attached a copy of a UK publication as proof of such change rule problems that caused many booked and paid for visits not to occur in September 2019. 4, her agency experienced problems with hotel and airline refunds. 5, Attorney Mia could not do his Umrah travel because of the travel agency's woes and is helping to sort them out. She attached a letter from Mia attorneys dated 18th October 2019 explaining away the agency's failure to refund would-be pilgrims within 21 days. Said letter further extended the time the agency gave itself to do refunds to 20th November 2019. The above general explanation does not precisely clarify what happened to Seedat and Patel's money. And there's no proof of its fate beside subtle hints that they may have had the same misfortune as other unnamed aspirant pilgrims who got affected by changed Saudi travel regulations. Nor does the explanation state why there's no refunds or full refunds to them since Mia attorney's letter. Now, primordial of any relevant other case that is pending or opened docket against the accused that I have to have regard to. My job in this case is to see whether prima facie the bail applicant has a case to meet during trial for allegedly scamming Seedat and Patel. The 3 omissions that I earlier referred to from the accused affidavit are glaring and call for answers thereto. If it's to be said that she may probably be acquitted during the trial. Hussein J considered the approach to bail affidavit evidence in bail proceedings and concluded that a magistrate had misdirected herself in Golan Mfeketo and 2 others versus the state. That case is case number CA and R 193/2014. by the Eastern Cape Division of the High Court of South Africa in Grahamstown. A judgment delivered on the 21st July 2014. He stated at page 6, paragraph 21, that such evidence as is accused on affidavits does not fall to be accorded little or no weight. It may well be that it is less persuasive. However, that does not mean that it is to be disregarded. More to the point for this case is what he pointed out in the middle of paragraph 21 of page 7, where it reads, and I quote, "To the contrary, in most respects, the evidence of the investigating officer supported the averments made by the appellants. Such evidence properly before the court ought therefore to have been considered, ought therefore to have been accorded due and proper consideration and weighed in assessing whether the appellants has established that it is in the interest of justice that they be admitted to bail. This the magistrate did not do, and in not doing so, she misdirected herself." Now, in this our case, the investigating officer states about the facts of the case in his first affidavit, that is Exhibit C, to the effect that in April 2019, the accused had quoted the Isaac family 49,497 rand. The charge in count 2 mentions that amount in relation to Ahmed Patel. So perhaps the IO meant the Patel family when he says the Isaac family. The IO further narrates that in May 2019, the complainant saw an advertisement for pilgrimage to Saudi Arabia from New Heights Travel and Tours, operated by the accused, Fazila Malek. They contacted her and she quoted the Seedat's family 105,993 rand, and full payment was made. The Asik family, he says, but as I then suspect, it's the Patel family, as per count 2, had made a deposit and were later called by the accused son, Mek Khan, telling them to urgently make the full payment, as Fazila, his mother, was in Saudi Arabia waiting for their payment so that she could pay for their accommodation. Out of trust, they paid, and they later realized that they were scammed, as the accused kept telling them that they will undertake the trip or receive their monies within 21 days. Months later, they opened up cases. Now, that paragraph from the investigating officer's affidavit clearly supplemented or corroborated the accused's version that she operated a business dealing with travels to the holy cities in Saudi Arabia. If the first family, that is the Esak or Patel family, was quoted in April 2019 before the advert was flighted in May 2019, prima facie, the business may have had clients without necessarily flighting adverts. In other words, its existence was known to clients. The Isaks or Patels accepted word from the accused son and paid the outstanding balance after initial deposit on hearing that she was in Saudi Arabia, based on trust, probably because they knew New Heights Travel Agency existed. Trouble started when the tours failed to materialize and refunds were not made, and clients opened up cases alleging being scammed. It would appear there'd be no scam allegations if refunds were made. Now, one of the more common scams I know of is phishing, but the IO's affidavits do not allege it's what was suspected of the accused. The same dictionary I mentioned says phishing is the activity of tricking people by getting them to give their identity, bank account numbers, etc. over the internet or by email, and then using this to steal money from them. Another popular scam is the advance fee scam, whereby people are persuaded to pay money in advance to a non-existent entity or an individual with falsified identity or false bank account for a purpose that is equally false in order to get huge returns on the advanced fees. At first blush, the investigating officer's affidavit appears to allege this sort of scam against the accused in the second paragraph of Exhibit C, dealing with the facts of the case. He says that in 2 other Lenasia cases, her sons prompted people to make payments quickly to the accused for trips that were known to be false. At Athlone, Cape Town, Zinat Khan and Ahmed Khan did the same in 3 more cases. The investigating officer then says these crimes were organized as the suspects advertised packages with the Lenasia Times Group and scammed people. He then says the accused resides at 8274 Scorpio Drive, extension 9, Lenasia, and she stated that the business no longer exists. This gives the impression that at some point there indeed was a business. The investigating officer's third affidavit, that is Exhibit E, reads from line 7, paragraph 2, that the suspect has passports and was a travel agent for over 20 years with connections in the Middle East. Agent that existed or operated for over 20 years created doubt as to the strength of the state's case. Some of his assertions about the accused and her travel agency, though also not tested evidence, added grains of truth to the accused's affidavit, which is to the effect that all she did was own and operate New Heights Travel Agency that ran into difficulty. But merely accepting all that affidavit-based evidence and holding there was no case for the accused to meet at trial would be clinging to legal formalism. The difference between Cox's case that says doubt as to the strength of the state's case is to the accused's benefit, and the Falyun and Botha cases that require the bail applicant who takes a tilt at the state's case to show he or she will probably be acquitted, is the angle or degree from which the Supreme Court of Appeal judges viewed the relevant issue of the strength of the state's case. So, lest it be said, I denied the accused victory on this point. to the extent that Cox's case said, where there's doubt as to the strength of the state's case, it works to her benefit. I should point out that I am the trial court here that has to look into the facts and am possessed with the tools as per section 50 subsection 6D of the Criminal Procedure Act to be inquisitive or inquisitorial and ask for evidence or information if that would be in the interest of justice. So I felt I had also to look at the other angle in order to do justice to this case, instead of merely doing legal formalism and saying, well, it appears there may be, in fact, there's doubt as to the strength of the state's case, therefore it works to the benefit of the accused, and go on and consider other matters in this bail application. So as I saw it, the information that would clarify the existence of New Heights Travel Agency would consist mainly of documents from the past. So would information on the fate of Seedat and Patel, that is the complainant's money. Failure to produce such information would not have helped the bail applicant's cause, while the state would have been granted the opportunity to verify the requested information. In terms of section 50 subsection 6D, Roman figure 5, I would have granted a postponement in the interest of justice if the state needed it, so as to oppose or refute the veracity of the information requested. As it turned out, save for having information that was not asked for by court redacted, the requested information was entered into the court's record with the consent of the state. The documents show on the face thereof that New Heights Travel Agency was registered as a closed corporation on the 17th April 2003, and the accused was one of the members. The agency was accredited on the 13th June 2007 as an approved agent by the International Association of Travel Agencies. Travel to and accommodation at Saudi Arabia by the Seedats and Patels was booked and paid for. The business address of New Heights Travel Agency is shown as being the same as the accused's residential address, and some financial or business activities in connection with the agency were conducted via the net bank. That's the information I got from the documents that were requested. Though it may be of little comfort to the complainants, the accused explained that refunds to them are delayed by service providers that were paid in advance. At first sight, therefore, and to the extent that not only the accused word, but also the documents admitted with her supplementary affidavit, which were not opposed or gainsaid by the state, also show there's credibility to her assertion as well as that of her attorney, that she may be acquitted during trial. So, having looked at the matter from both the angle, that is the matter of the strength of the state's case, the angle as to whether or not there's doubt as to its strength or weakness, as well as the angle of whether she is likely to be acquitted during trial, I could find nothing to the effect that she is not likely to succeed in trial at this stage, I must add, because the investigations are still ongoing. But as we all know, I have to decide this bail application based on information before me at this stage. Now, the major issue then for this bail application is where the interests of justice lie. Where those lie are indicated by the likelihood that the accused, if released, as stated in Section 60, subsection 4 of the Criminal Procedure Act, A, would endanger the safety of an individual or the public or commit offenses further. B, would attempt to evade trial. C, would attempt to influence or intimidate witnesses or conceal or destroy evidence. C, would undermine or jeopardize the criminal justice objectives or proper functioning as well as, or its proper functioning as well as those of the bail system. E, in exceptional circumstances that should disturb public order or undermine public peace or security. Sections 65 to Section 60, subsection 5 to 9 of the Criminal Procedure Act has sub-factors that this court must take into account in considering the probability of the main factors in Section 64A to E occurring. As previously stated, Stanfield's case justified continued incarceration if only one of the Section 64A to E main factors is likely or probable. But that said, in Branco's case by our own Johannesburg High Court, there's qualification of the Stanfield decision that was made in 1997. In State versus Branco 2002, Volume 1, SACR 351 brackets W, Kachalia AJ, as he then was, stated that a court should always consider suitable conditions as an alternative to denial of bail. Conversely, when no consideration is given to the application of suitable conditions as an alternative to incarceration, this may lead to a failure to a proper discretion. Thus, although the accused's continued detention is justified for Schedule 5 offenses, doing so when there can be amelioration of the situation by admitting her to bail under proper and effective conditions aborts the criminal justice and bail system. I'm not convinced that the accused is a proven flight risk, though that is probable. Her identity number is the same as in her agency's registration documents and the documents on the passports inquiry that came with the requested information. Her first names there are the same too, though the same names differ. Although there's valid concern that her affidavits mentioned different numbers of valid passports. There's no reason not to accept that the different surnames are due to marital history. She has lived her life as Fazila Bibi, and society would have known her as that person. In addition to the first names, the authorities also know her by the consistent identity number they gave to her, and which she is not likely to want to change if that were possible during the life of this case without raising suspicion. She can be ordered to give all passports to the state and not obtain any other. She can be ordered not to have an identity document with changed or altered names or means of identification. Failure to abide by such bail conditions, if imposed, may result in her being put back into the slammer if released. I requested the accused and the state to bring the court information with regard to verification of the passports. Although the state feels the request for more information from the accused lessened the pressure on the accused, I believe I've satisfactorily explained my thoughts that were influenced by the Untitled Judgement. Indeed, the request as to passport verification was a follow-up on the state's failure to do so, which persisted till the last hearing. Far from loosening the pinch of the accused's shoe, as was argued, should the state find that the document on the passports, ostensibly from the Freiheit office of the Department of Home Affairs, is not kosher, they may well have the accused brought before court to explain herself. The decision as to whether she is a flight risk is partly based on that passport verification and may well be reversed if there is sound reasons so to do. The same may hold true for the other documents that came as a result of the court's request, and which documents got into the record by the consent of the parties. The information I requested regarding what happened when the police went to the accused's home and eventually arrested her still does not remove the spectacle that she attempted to hide in her domestic quarters when the police were there looking for her. Much can be said about the investigating officer's handling of his communication with the accused since the start of the case in about November 2019. But the spectacle of the day of the accused's arrest does seem to indicate that she was hiding so as not to be arrested. Now, it's not my function to be an armchair critic and decry the actions of the investigating officer, who may have trusted that as a reputable business person rooted in Lenasia, the accused would cooperate with him and go to the police station on request. What's a bit strange is that although on his word there was communication with her, he had not ascertained her residential address and only traced it just before arrest. While it may be that there were threats directed at the accused, the investigation of this case started in November, and there was a long enough period before the outbreak of COVID-19 this year, and the resultant restriction of her movements. For her to have met the investigating officer of this case, had she prioritized that? My conclusion as to the factor in section 60 subsection 4b is that the accused is a probable flight risk, but evasion of trial may be prevented through suitable bail conditions, including house arrest and electronic tagging. The accused circumstances differ from those of Supersad in cardinal ways, as she is rooted in Lenasia through work or business, residence, and family. Supersad was a proven fugitive from justice with a warrant out for his arrest. He had many cases actually pending before court, in respect of which he dishonored his commitment to court and had already jeopardized the bail system by the time he applied for bail. As a proven flight risk, there was no reason to doubt that he would again flee and or commit other crimes if admitted to bail. The current applicant may be stopped in her tracks from even starting those activities by house arrest and strict monitoring. Personal physical contact with state witnesses or potential state witnesses to influence or intimidate them may also be prevented or eliminated through house arrest and monitoring, forming part of the bail conditions. While one is concerned by the accused's lack of openness and being forthcoming with documents having a bearing on and being not forthcoming, rather, with documents having a bearing on the case, even in this court, the police have wide search and seizure powers with which to obtain them. If the lack of openness is due to a desire to conceal or destroy evidence, those powers can be used. Other parties like the complainants and service providers to the agency, New Heights Travel, may also provide same. Now, while this case has not resulted in marches by the public to this courthouse that I'm aware of, perhaps because the COVID-19 restrictions has made even the numbers of people allowed inside this courtroom to be very limited. The investigating officer's affidavit, that is Exhibit C, says some victims have lost hope in the criminal justice system. Very strict bail conditions may restore their hope and trust in the system and may also quell whatever disquiet there may be in the public space. Now, as to the bail amount, there's been no formal hearing of evidence dedicated to it. That is, statements of assets of the accused and or those that are inclined financially or otherwise to promote her admission to bail, a spreadsheet of what New Heights Travel owns, etc. But I know it operated from where the accused resides. That house may well be owned by the accused and or her agency, or both. Can also happen that it's owned by her and or partner or some benevolent person who may sponsor her admission to bail. So if the bail amount of 20,000 Rand I now said can justifiably be altered, A formal hearing as to bail reduction could be held in due course. I'm influenced as to the justness of 20,000 rand by the fact that there's a substantial amount of money currently said to be lost by the complainants, which has not yet, if ever, been refunded. Though for this specific case, that monetary amount is nowhere as high as the figures mentioned earlier in respect of SuperSat. I thought of requiring an additional bank guarantee for an additional higher amount secured by property, especially the house registered as the business address of New Heights Travel. That was influenced by the fact that the documents mentioned against the accused are, as stated earlier, more than those in SuperSat's case. However, as she will continue to be in custody even after this judgment, I will not overplay my hand. Her continued incarceration may give the state the opportunity to do the quick assets check, like a deed registry search as to the ownership of the property, such that a guarantee of the sort I mentioned earlier could be made when bail or release issues are considered for the case I refuse to join in this bail application. Now, years back, I required such a guarantee in a case involving a gun shop owner, his assistant, and soldiers from the military base on the other side of the railway line next to this court. It was alleged they stole arms and ammunition from the base and were involved in gun running up to the Democratic Republic of the Congo in violation of the country's sovereignty. The gun shop owner's personal and business affairs were arranged, as I saw it, such that he could flee to live abroad whilst continuing with the business. House arrest and other stringent bail conditions around the various accused persons' personal and business or work life ensured that the bail system worked, even though the gun shop owner was arrested, seemingly about to flee from the airport. Now, that bail application and trial were done by the former senior public prosecutor of this court, and close to 2 years later, and without opposition from her, 2 of the accused came to apply for a release of some of the bail money to fund litigation costs. The applications were granted without opposition by the state. The gun shop assistant augmented his earnings by participating in shooting competitions, even abroad. With strong opposition from the state, he applied for temporary leave to attend such competition in Greece. I granted it, and he came back as the bail conditions were such that not only he, but also those near and dear to him would suffer if he did not abide by the bail system. The next time he did a similar application, it was unopposed. Still, he came back as the strictures around his release were such that failure to obey them would trigger off what would amount to a disastrous booby trap for him and loved ones. The point of this is that what I call the leash and dead-end approach in admitting a person to bail can be used in appropriate cases where the accused justifies getting bail, as opposed to continuing to keep them, to keep him or her in custody. The point is that house arrest, tagging, and other buffers or dead ends constructed to reduce, if not totally eliminate, failure of bail justice can still creatively be used in the matters against the accused. Currently, her continued incarceration resulting from the refusal to join the pending other case in this bail application is a big stumbling block, such that even though courts normally cannot foresee if a bail applicant may jeopardize the bail system, here I know chances of that occurring are eliminated in the immediate term by the other case. And in the long term, should the physical incarceration from that and other likely cases no longer be there, a portion of the bail system is safeguarded by current bail conditions which may be imposed upon in this as well as other cases. So the bail conditions that I thought would be fair and just are the following. The first, the accused must continue residing at the house number 8274 Skopje Drive, extension 9, Lenasia, and not change residence without notifying the investigating officer 7 days in advance of the mooted change and the new address at which she will reside. Secondly, at all times the accused must be at her residence and may only be absent from the residence when attending at court, reporting at a police station, or when authorized thereto by the investigating officer for medical, religious, or other necessary purposes. Thirdly, when required by the state, the accused must submit to electronic tagging or having a device on her to monitor her movements or compliance with bail conditions. Fourthly, the accused must not contact or interfere with any state witness or potential state witness. Fifthly, the accused must send over to the investigating officer all her travel documents and not obtain any other. Neither must she have an identity document with changed or altered names or means of identification from the ones she now has. Sixthly, the accused must stop working as travel agent and desist from having others operate as such on behalf of herself. And lastly, the accused must report at, I did not name the police station because I wanted to be sure of the nearest police station. Mm-hmm. Lastly, then, the accused must report at the Lenasia police station every Monday at 10 o'clock. These conditions of bail will apply for the duration of the case or until the amendment or revocation of any of them by a court. The accused must then stand up. At this point, your case is postponed to the 24th June 2020. You'll make appearance at the Protea Regional Court number 10 at 8:30, pending finalization of investigation. You are remanded in custody. Bail is set at 20,000 rand, subject to the conditions of bail already spelled out Should you pay bail, you must be at Protea Regional Court 10 at 8:30 on the 24th of next month at 8:30, and there remain until your case is dealt with. Should you fail to attend at that court at 8:30 on the 24th next month, or having failed to remain, or should you breach any of the bail conditions, a warrant for your arrest would be authorized, the bail may be cancelled, and you may be kept in custody until the case is finalized. That is the judgment. Oh, there's one more aspect that I nearly forgot to mention. Just so I don't get people, especially in chambers, trying to stretch the string or limit it to their own advantage, I feel the need to state what I mean specific to these bail conditions, so that people don't approach me in chambers because they encounter certain difficulties or want to achieve certain ends. I'm not saying people cannot come to court about those bail conditions, as the Criminal Procedure Act allows them to have the bail conditions taken to court. They can also be taken up with the higher courts in any event. So the first bail condition is that she must continue living at the place where on the registration papers of her agency she ran the business. If she wants to change a place where she wants to live, she first has to notify the investigating officer 7 days before the change that is required. Firstly, that I want to change my address. And secondly, that I want to go live at this specific address. The object being that within that 7-day period, the investigating officer will do what is normally called address verification. I think that much is a bit is clear. The second one says at all times the accused must be at her residence and may only be absent from their residence on attending at court, reporting at police station, or when authorized thereto by the IO for medical, religious, or other necessary purposes. It does not say if the accused has a necessity to be away from home. She is debarred from leaving home. All it says that is that when she has to come to court or go report at a police station, she does not have to get authorization from the investigation office. Obviously, because the investigating officer would know the court dates as well as the days she's supposed to report at the police station. But for other reasons, if she is to be absent, for instance, for medical reasons, religious purposes, and other necessary causes, the investigating officer has to be approached for authorization. Of course, if that authorization is unreasonably denied, the matter may then be taken to court, not so. In many instances where there is a dispute concerning those, the prosecution would be approached. If they still disagreement, the matter is taken to court and we look into it and find our way through it. The third one is that when required by the state, the accused must submit to electronic tagging or having a device on her to monitor her movements or compliance with bail conditions. It directly speaks to this aspect of that I already mentioned. She is a probable flight risk. Therefore, there is a need to monitor. It also speaks to the addition of the measures of lessening her being a flight risk. That is the first of those measures being the house arrest. All it says is that if the state so requests, she has to agree to a tag, an electronic tag being placed on her, so that perhaps when she moves between the house and police station or house and hospital or house and court, they may be able to monitor her through the tag, or they may request that, okay, we are going to phone you as you move between your house and court, so as to establish whether indeed you are going to court or you are in court, so as to see whether you comply with the bail condition. Perhaps ask her for a cell phone number. It also speaks to the condition that she must not contact or interfere with any state witness or potential state witness, to the extent that the police will also know if she continues to phone the state witnesses. Perhaps if they have a cell phone number that they have given to her, that she has given to them. And conducting or interfering with state witness or potential state witness does not only refer to those persons that she knows, the complainants in this matter. There's other matters in respect of which she has been charged or is to be charged. Those two are potential state witnesses or state witnesses. And were she to have others contact those persons, that's also interfering with state witnesses, not so. And then the fifth says she must hand over to the IO all travel documents and not obtain any other. That one is very clear, and I would suppose by now same would have been given to the investigating officer. Neither must she have an identity document with changed or altered names or means of identification from the one she has. By means of identification, I mean changing an identity document with a view to having another identity number now. I don't think that's easy to do, but to the extent that in this bail application, there's a lot involved. People have, as alleged by the state, had their trust abused. So it's incumbent on me to make sure that I try and cover every angle to the extent that the accused may be out of prison and they are aggrieved persons that trusted her, perhaps based on the reputation of her agency, or perhaps they are also fellow Muslims, as she's also a fellow Muslim like those other persons. You see, it hurts that when one that you regard as one of your own is alleged to have done things as is alleged by the state. Therefore, one has to be very careful in dealing with a matter like this and crafting bail conditions. Accused must stop working as a travel agent and desist from having others operate as such on behalf of herself. Now, in our law, a company or a close corporation has separate identity from that of an individual. Ne? It may well be that the CC is still continuing to operate. Ne? But the accused should not be involved in running its affairs. I know she's a member, but for purposes of the smooth running of this matter, she should desist from running its affairs or indirectly through others influence the running of its affairs, or herself, even if not through the agency, continue doing the work of a travel agent personally. She has to desist from that. The one as to reporting at a police station, I think, is also very clear. The object of this is that my function with this case is now done. I am called functus officio. I've exhausted my jurisdiction in respect of this case. If any other issues arise, they will have to be addressed in court. I don't want to be approached in respect of clarification of bail conditions and the like in chambers. Court adjourns.